the National Constitution Center. Today I'm actually in DC, but I'm excited to be in class with you. And we're going to go through all the key Supreme Court cases that are a part of the AP government test. So a lot of our students that are joining today are taking this test in the next week. We wish them luck. You got it. You can do it. Remember to breathe and don't chew gum. Steals oxygen from your brain, at least that's what they tell me. But you'll be able to do it. And to help you in that, we're going to wish you good well, but we also brought in Jeff Rosen to walk you through these 15 key cases. So Jeff, you want to welcome our students and tell them any good vibes that they need to know walking into a big test?
Welcome, friends. I'm sending you such good vibes. My favorite chemistry teacher in high school, before I took the chemistry AP, just told me to go relax and see a movie before the test. And I thought, how could that be? I got to study to the last minute. And I probably didn't take her advice because I was such a keyed up student. But she, of course, was absolutely right. You already know this. You've got this. You've been with us all year. And this review, after this review, all you got to do is relax and you're going to rock it for the test. So my job is to get through 15 cases in 30 minutes. We'll see how I do on that test. And we're going to begin with Marbury versus Madison. Marbury's the case that everyone always begins with, and the facts are really complicated. So let me see if I can just do it as quickly as possible. The big idea, of course, is that Marbury establishes the principle of judicial review, the idea that the Supreme Court has the power to strike down unconstitutional laws. You know that the power of judicial review didn't come from Marbury versus Madison. Hamilton recognized it in Federalist 78 as inherent in the very idea of the Constitution as supreme law, because as Hamilton said, whenever there's a conflict between the will of the people represented by the Constitution and the will of the legislature represented by ordinary laws, you prefer the principle to the agent. Marshall established that in Marbury, but it was a very fraught political time. We think we've got big polarization now. Well, it was as polarized or more in 1803 when Marbury is decided. Jefferson's won this unbelievably contested election of 1800, and the outgoing Federalists are so determined to block him that they change the size of the Supreme Court to deny Jefferson the ability to make any appointments. Jefferson changes it back when he gets in. And Jefferson and Marshall are ardent rivals and distant cousins. They can't bear each other. Marshall calls Jefferson the great llama of the mountain, and Jefferson accuses Marshall of twistifications. He says, whenever Marshall asks me something, I'll say, I don't know, because Marshall will twist anything I say against me. So the difficulty of Marbury is that at the last minute of the Adams administration, Adams is frantically staying up all night to appoint these so-called midnight judges right before his term expires. And among the judges he appoints is a guy called Marbury. The problem is that Marbury never gets the commission appointing him to the judgeship. And that's because the Secretary of State, who's supposed to deliver it, forgets to deliver the commission. And the Secretary of State is, drum roll, John Marshall. Unbelievable. John Marshall is standing there with Adams. He's supposed to deliver the commission. He forgets it. Then Adams appoints him to the Supreme Court. Can you imagine? Obviously, by today's standards, Marshall should never have heard the case because he was the guy who forgot to deliver the commission. Different time. But Marshall's in a tough situation here because Marbury says, I want you, Supreme Court, to force President Jefferson and his Secretary of State, James Madison, to deliver the commission to which I'm entitled because it was signed. Here's Marshall's dilemma. If he agrees with Marbury and says, yes, Jefferson and Madison, you got to deliver the commission, Jefferson will just ignore him and it'll reveal Marshall to be weak and the Supreme Court to be a paper tiger. If, on the other hand, Marshall ducks the fight entirely, he'll look like he's the one who's weak because he's kind of chickening out and afraid of Jefferson defying him. Marshall extracts himself from this dilemma with an act of jujitsu that still inspires awe with its sophistication. Marshall acknowledges that Marbury has a right to his commission. He says ordinarily when there's a right, there's a remedy. Presumably, we should be able to order that the commission be delivered, but, says Marshall at the last minute, this is called a volta in a Shakespearean sonnet. You're going along, and then in the third stanza, there's the but. Marshall says the federal law authorizing the Supreme Court to hear cases of this kind is itself unconstitutional because it expands the Supreme Court's jurisdiction beyond the limit set in the original Constitution. isn't that brilliant? Marshall has both avoided a conflict with Jefferson that he knows he's going to lose in the short term while shoring up judicial power in the long term. And as a result, the Supreme Court became the strong body that we know today. All right, Curry, I know that was too long. I just got excited about Marbury.
It was, it's funny because it's not always my favorite case to hear about because it's so complicated, but when you say judicial jujitsu, it cracks me up every time because it really is. But for the students, you connected it to Federalist 78, and that's a great thing to do on the test. And you might see questions that have you compare it to different documents and connect the dots. And that's what the AP test really looks for. So thank you for pointing that out. Now, the next two cases, we're going to bundle them together. The AP Gov test really looks at this under the wing of federalism. So McCulloch and United States v. Lopez.
Great. Big picture here. McCulloch comes up with a expansive and generous idea of Congress's power to regulate the economy. And Lopez in 1995, a century later, says that power has some limits. It's not unlimited. So McCulloch is the biggest policy debate in the early republic over the constitutionality of a national bank. Alexander Hamilton came up with the idea of a national bank. Washington supported him. But initially, James Madison and Jeffersonian Republicans said Congress had no power to create it. After the national bank is chartered, the state of Maryland passes a law imposing taxes on it because it's trying to kind of destroy the bank and challenges Congress's authority to establish a bank in the first place. And Chief Justice Marshall, in next to Marbury, the defining case of his tenure, says Congress does have the power to establish a bank under the necessary and proper clause of the Constitution. Congress has powers that are not explicitly listed or enumerated in the Constitution, and therefore can establish a bank under the idea that actions that are appropriate and legitimate and support the enumerated powers are permissible. In addition, Marshall says the power to tax is the power to destroy, and because the bank was legitimately established, Maryland estate cannot tax it. There are a lot of famous quotes in McCulloch. We must never forget it's a constitution we're expounding. That both sounds very resonant, and also it's not exactly clear what it means. And what I think Marshall is saying is, don't read the Constitution like a tax code. Don't assume that every single power has to be specifically spelled out. You don't have to have a "you can charter a bank" clause. This is a broad set of principles that should be construed appropriately and expansively, as long as the end be legitimate. Any means that is appropriate to carrying out the end can be within Congress's power. And that's the next famous quote: "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adopted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution, are constitutional." Very big case. And in the end, Madison changes his mind about the constitutionality of the bank and comes to accept it. Let's fast forward almost 200 years to 1995. Federal power has dramatically expanded over the course of the 20th century. And during the New Deal era, especially after 1936 and the court switch in time, the court basically got out of the business of striking down federal laws as beyond Congress's power under the Commerce Clause of the Constitution, which gives Congress the power to regulate interstate commerce. And in fact, the court struck down no laws as exceeding Congress's Congress power between 1936 and 1995. But in the 1995 Lopez case, Chief Justice Rehnquist says there are some limits to Congress's power. It's not a blank check that allows Congress to do whatever it wants. And the case here involves guns in schools, a very salient topic for all of us and all of you. And Congress had passed a law called the Gun-Free Schools Act of 1990, which didn't allow you to have guns in schools. And Lopez challenges his conviction for carrying a concealed weapon into high school because he says Congress has power to regulate interstate commerce, but can't regulate things that are not an economic activity. And the Supreme Court agrees with them. They hold in this 5-4 decision that carrying a gun in schools is not an economic activity, and is therefore Congress has no power to regulate this kind of private, non-economic activities under the Commerce Clause. It stands for the basic proposition that the national government is one of limited powers, And the court holds that if Congress is trying to regulate a non-economic activity and the activity doesn't substantially affect interstate commerce, then it's beyond Congress's power. So you can regulate non-economic activities, but they have to have a substantial effect on interstate commerce. And Lopez establishes a framework for evaluating constitutional challenges to congressional laws. This debate came up again most recently in the Obamacare case, where the court upholds Obamacare by a 5-4 margin, but not under the Commerce Clause. Chief Justice Roberts joins the more conservative justices in saying that forcing people to buy healthcare is not an economic activity. It's like forcing people to buy broccoli or to have gym memberships, and therefore it exceeds Congress's power under the Lopez test. But Chief Justice Roberts joins the liberals in upholding it and attacks. Big picture, McCulloch establishes broad power to regulate the economy as long as the end is legitimate. Any means chosen that are consistent with the letter and spirit of enumerated powers are permissible. And Lopez says Congress's power is not unlimited. And if it's a non-economic activity, it has to have substantial effects on the economy. How's that, Curry?
That was perfect bookends. Really appreciate it. Now, the next grouping really looks at the Bill of Rights and balancing order and liberty. That's how the AP Gov kind of frames it. And we have a list of speech cases, some in schools, some outside of schools, that really kind of pop up to a big piece. This is the order that they kind of walk through it. We know that it's not in timeline order, but Jeff, you can go in any order you want. If you want to start with Shank, we can do that too.
I think we should keep the AP order because we have 2 religion cases and then 3 free speech cases. So that is
great.
A good way to organize them. So the 2 religion cases are very important. Friends, you know, the Supreme Court last week heard this, or actually on Monday, I think, heard the praying coach case. Fascinating case. We did a great We the People podcast on it if you want to check it out last week. And one question is, under what circumstances can you have prayer in schools? And a lot of the debate stems from this Engel versus Vitale case, which was decided in 1962 and was the landmark case that struck down a New York law that authorized public schools to recite a short voluntary prayer at the beginning of every school day. Students challenged the practice, saying it violated the Establishment Clause of the First Amendment, which says Congress shall make no law establishing religion. And the court, in a 6-1 decision, struck down the New York prayer, said that state officials can't compose official state prayers and require that they be recited in schools, even if the prayer is denominationally neutral and students can opt out. Why did the court hold that? This is very important in order to understand the case, that you understand the principle. So the Establishment Clause says Congress shall make no law respecting an establishment of religion. What's an establishment of religion? Well, when the Establishment Clause is passed, a bunch of states actually had established religions, like Virginia established the Anglican Church. And if you were not an Anglican, if you were a member of a dissenting group like the Baptists or the Quakers or the Jews, you could be put in jail for 3 years for preaching your faith. You could be fined if you didn't attend Anglican services, and you could be not allowed to hold office if you weren't an Anglican. So Thomas Jefferson and James Madison wrote the most beautiful statements of religious freedom in all of American history, opposing this establishment. And I would love you, maybe not this weekend, because I know you've got to, we talked about it last week, but you're studying for the test. But when we open the First Amendment tablet on Monday, I'm going to talk about how Jefferson's draft bill for establishing religious freedom in Virginia, which he first drafted in 1779, basically defines the scope of modern free speech law today. And the basic argument that Jefferson had, which was echoed by Madison in his memorial remonstrance against religious assessments, is that because the opinions of men and women, being the product of evidence involuntarily contemplated by our reasoning mind, cannot be compelled or controlled by anyone else. In other words, I can't give you the power to form my opinions because they're the product of my reason and the evidence that my mind contemplates, and I have both the right and the duty to think for myself. It's a very powerful idea. So now you understand why the founders are so opposed to a congressional establishment, because they think that Congress can't try to coerce individuals from exercising their unalienable rights of conscience. And the Engel and Vitale case basically says that when the school invites people to pray, even if it's non-denominational, and even if you can opt out, there's coercive pressure to recite the prayer. You know how it is in school. If your teacher says, hey, I'm just going to recite this prayer, you don't have to if you don't want to, that's your right under the case that we read about West Virginia and Barnett that said you can't be forced to salute the flag. You're going to feel some pressure to do it anyway. And the court says that that kind of coercive pressure to say the prayer violates the Establishment Clause. Now, there's a huge amount of debate that's followed Engel and Vitale about what constitutes coercion, what kind of subtle pressures. Is it coercive if the coach is on the 50-yard line and he's invites people to pray but says you don't have to? What if he's just doing it on his own before the game but says you can join me before the game? You know, these are complicated questions that people disagree about. And there's been a lot of case law since Engel and Vitale about whether the coercion test is the right one or whether the test the court has actually adopted called the endorsement test in the Lynch case, which says that when a state expression of religion seems to endorse religion, it's unconstitutional, whether that's the right test or not. But all you got to know is that Engel versus Vitale basically establishes a version of this coercion test and says that prayer in school is inherently coercive. Fast forward to Wisconsin v. Yoder, 72. 3 members of the Amish faith bring a First Amendment challenge against the state of Wisconsin. They say that a state law requiring all children to attend public schools until 16 is contrary to their religious beliefs, which forbid sending their children to school after the 8th grade. The unanimous Supreme Court agrees with them and says that the individual's right to free exercise of religion outweighs the state interest in requiring Amish children to continue in public schools beyond 8th grade. Yoder is the free exercise clause, not the Establishment Clause. It involves the individual's ability to practice his or her faith, not the state's attempt to impose a religion on everyone else. And it involves this question, which is very alive today, about when must the government grant accommodations to religious individuals who claim that a law violates the basic tenets of their faith. And the Yoder decision is one of the most powerful decisions, granting a religious exemption from a law that applies to everyone. And that question is being hotly debated in cases today, ranging from the baker who doesn't want to bake a cake for the gay couple to COVID exemptions from members of churches who say that they didn't want their religious services to close down during COVID. So that's the Establishment Clause under Engel and Vitale and the Free Exercise Clause under Yoder. How's that, Curry?
That's great. Students, that's great to make those modern connections too. And also another sub-theme here is schools. So one more case on the First Amendment in schools is a classic Tinker.
Yes, we'll do Tinker, and then we'll do the other 2 central First Amendment cases. Tinker is perhaps the most important free speech case in schools. It was decided in 1969, and it involved high school students who wore black armbands to school to protest the Vietnam War. And they were disciplined by their school for wearing the armbands. They said that this was a form of symbolic protest that should be protected under the First Amendment. And the Supreme Court agrees, 7-2. It says that the armbands are a kind of symbolic expression protected under the Free Speech Clause, that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. That's the quote. And the full quote is, it can hardly be argued that either students or teachers shed their constitutional right to freedom of speech or expression at the schoolhouse gate. So you, students and teachers, do have some First Amendment rights, but the rights are not as robust as adults outside of school. Tinker says students may have their speech rights limited when the speech materially or substantially interferes with the school's operation and its central mission, which is teaching students. So that's the test. Does the speech materially or substantially interfere with the school operation? And in Tinker, there was no actual interference. The school just feared potential disruption, and that couldn't survive a First Amendment challenge. Friends, the question of what's a substantial and material disruption, and also what counts as the school, is very much more complicated in the age of the internet. And just last term, the Supreme Court in the Mahoney case, the BL case, said that a cheerleader couldn't be disciplined for cursing on Snap because it was both off campus and didn't materially and substantially disrupt school. And the court reaffirmed the idea that you do have rights even online. It didn't settle all the questions. It didn't draw a really sharp line between off and on campus speech as the lower court had done, and it left plenty of questions undecided. But that was another unanimous decision written by Justice Breyer, and it reaffirms Tinker. So that's Tinker, and that's student rights. And the basic test is that there is a right to free speech as long as the speech doesn't materially and substantially interfere with the school operation. Now we have two very important cases involving the rights of adults, which are also being hotly contested in the age of the internet, to put it mildly. First is New York Times versus Sullivan. New York Times versus United States. It's important not to be confused between those two cases. Times and Sullivan is another free speech case, but the one you have for the AP exam is the Pentagon Papers case. That's New York Times versus Sullivan. And the New York Times publishes this long article called the Pentagon Papers about the history of the US's involvement in Vietnam. And the government tries to stop publication of the New York Times, trying to issue a prior restraint. And in fact, a lower court judge actually does try to stop the presses on the grounds that publication might violate the Espionage Act, which prohibits unauthorized publication that might be used to the injury of the United States. And the court disagrees that you can have prior restraints. And in an unsigned per curiam opinion, the court said any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. So almost all attempts to stop publication before the fact are unconstitutional and violate freedom of the press. And the famous quote by Justice William O. Douglas is that secrecy in government is fundamentally anti-democratic. And Justice Hugo Black says the injunction against the New York Times amounts to a flagrant, indefensible, and continuing violation of the First Amendment. The press was to serve the governed, not the governors. The government's power to censor the press was abolished so that the press would remain forever free to censure the government. Great case, very inspiring, landmark. The problem is, what's the value of a barrier against prior restraints in the age of the internet? It's pretty hard to issue a prior restraint, even if you wanted to, in an age of instant publication. If Julian Assange wants to make a hack and publish something from WikiLeaks, he can just press the send button. He doesn't have to, start the printing presses. So this question of how to protect the press in an age when there's not a lot of prior restraints remains alive. But the principle of New York Times versus Sullivan is that the government can't try to stop publication before it happens, remains very much alive. And our final case, and this is so much fun to share with you because it's such an amazing defense of free speech written by Justice Oliver Wendell Holmes, is decided in 1919. It's the Schenck case. It also comes at a time when all of the free speech law is being rethought. 1917, Congress passes an Espionage Act that makes it a crime to criticize the war. Eugene V. Debs, the socialist candidate for president, runs for president again from a jail cell in 1920 because he's been convicted under the Espionage Act for making a mild criticism of World War I. And the Supreme Court upholds a lot of those convictions, but in two landmark dissenting opinions and concurring opinions, Justices Holmes and Brandeis begin to disagree and establish a version of the modern test for free speech, which is that speech can only be restricted if it's intended to and likely to cause imminent serious injury or violence. That's an incredibly important test. It comes from the Brandenburg case in 1969, and it makes the US the most speech protective country in the world. Brandeis articulated it in Whitney versus California, which I'm going to talk about on Monday. Whitney very closely followed Jefferson's religious freedom bill and basically sums up the reasons for protecting free speech. But Schenck is very important because it's Holmes's earlier version of the test, which is called the clear and present danger test. It's not quite the identical. Let's just be lawyers here. There's a difference between saying that the speech has to pose a clear and present danger and saying that it has to be intended to and likely to cause imminent lawless action. But it's a version of the same thing. You can't just say the speech might have a bad tendency to inspire people to break the law in the future. You got to say it's a clear and present danger. It's immediate. There's going to be an instant result that's going to lead to violence, and it's intended as well. So you can't stand up in public and say and point to someone and say, go harm that person now, if you're standing in front of an angry mob that's likely to actually respond. But if one of you in the chat said, God, I wish someone would just, make Jeff stop talking. I'm so tired. I feel like I want to kill him. That should be permitted, I think, although it wouldn't be very polite, because there's no possibility that your speech is actually going to cause me any imminent or immediate harm. Now, what I'm going to do is, even though we may not have time for it, we have to make time for it, which is to read the beautiful paragraph from Shank. And Clary, while I'm finding it, because I love it so much, do you have any questions about those 3 free speech cases?
No, I think that was perfect. It really kind of lays out what happens in school, what can and cannot happen in school, and baselines, and then looks at the press, and then looks at free speech and how it's changed over time. So it's important students to bring it up to speed and not just leave it at Schenck in 1919. As you go there in a minute, I'll just tee up the next section. So students are ready to jump in the next section. This is looking at incorporation of liberties into the states with 3 key cases: Gideon v. Wainwright, Roe v. Wade, and McDonald v. Chicago. And Jeff, you can talk a little bit about these cases and kind of their current state as well. But I will say, just as a personal favorite, Gideon may be one of my favorite cases. It's just such an inspiring story about somebody not being treated fairly or justly, and then calling to the Supreme Court to right that wrong. So it has so many layers to it. But are you ready with Schenck now?
I am. I'll just read, just 1 or 2 of the sentences. Holmes says, and this is famous, of course, so you'll be familiar with it. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. It does not even protect a man from an injunction against uttering words that may have all the effect of force. The question in every case is whether the words used are used in such circumstances as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. So that's the famous clear and present danger language. If you want more, check out the decision and just read it yourself, because Holmes was such a beautiful writer. Okay, now we're going to talk about Gideon. We have Gideon, Roe, and McDonald. Oh my goodness. And okay, Curry, it's 1:30. So how much? Speed
version. You got like 2 minutes on each, and you're going to go to a rabbit hole with Gideon, so we keep it short.
I'm not. You know what? I'm going to do these really fast. But you know what I'm recommending to you, friends, for your pleasure? Read Anthony Lewis's Gideon's Trumpet, one of the great books ever written about the Supreme Court. If you can finish it without choking up at the end, then you have a harder heart than I, because it's just a beautiful book. So Gideon basically writes to the Supreme Court. He's convicted for being part of a pool room break-in, and he says he didn't do it, and he has a really bad lawyer and gets thrown in jail. And he is tried without a lawyer because he can't afford one. And he writes to the Supreme Court and said, the Constitution gives me a right to a lawyer. And the Supreme Court agrees. And in this landmark opinion, the Supreme Court says that denying someone the right to a lawyer in a criminal trial violates his 6th Amendment rights, because the 6th Amendment applies to all criminal defendants charged with a felony in state court. So if you're charged with a felony, then you have the right to a court-appointed lawyer, even if you can't afford one. And the amazing coda of the case, which you'll learn if you read Gideon's Trumpet, is that on his retrial, where he's represented by a really good ACLU lawyer, he's acquitted because the jury is convinced that actually he didn't do it. He was set up by someone else. So justice prevailed. An amazing case. Roe v. Wade, friends, all I can tell you about Roe v. Wade is that the court may change it any day. I mean, it's likely to be by the end of June, but the court is now deciding whether or not to overturn or narrow Roe, and there's a decent chance that it will change Roe in some form. But for your purposes, all you have to know is the holding of Roe, which is that the Constitution protects a woman's liberty to choose abortion. And Roe established a trimester framework, which was modified in Planned Parenthood v. Casey. But the basic idea is that early in pregnancy, there is a liberty to choose abortion, which can be balanced against the growing interests of the fetus later in pregnancy, so that later term pregnancies can be restricted and early term pregnancies must be protected. The constitutional basis for the liberty that the court recognized in Roe was the Due Process Clause, the 14th Amendment, which says no person can be deprived of life, liberty, or property without due process of law. That's why it's called a form of substantive due process. The idea is that the Liberty Clause has a substantive component, which is broad enough to protect a woman's right to choose her pregnancy. The court also drew on cases protecting the right to privacy, recognized in Griswold versus Connecticut, although it said that it ultimately rooted the right to Roe in the Liberty Clause. And Roe was subsequently reaffirmed by the Casey decision, which found that a woman not only has a liberty interest in abortion and an autonomy interest, but also an equality interest, that imposing burdens on women that are not imposed on men denies women the right to make fundamental choices about how to conduct their lives and careers. That was the Casey decision, and all of that is being reconsidered by the Supreme Court. So we'll see what they do. The final case is McDonald versus Chicago, the Second Amendment right to bear arms, which the court is also considering the scope of this term. But McDonald was an important decision, basically following up on the court's 2008 Heller decision, which for the first time said the right to bear arms is an individual right, and therefore DC's ban on gun possession in the home was unconstitutional. DC at the time was the only federal enclave to ban gun possession in the home. Chicago was the only city to ban gun possession in the home. And McDonald just piggybacks on Heller, and the two cases together say neither the states nor the feds can ban gun possession in the home because the right to possess a gun in the home is protected by the individual right of self-defense, which is recognized by the Second Amendment. McDonald and Heller left a whole lot of questions open, including what kind of reasonable restrictions are permissible. The court went out of its way to say that many reasonable restrictions are permissible, including restrictions on guns in and around schools when passed by the states. But the scope of those restrictions is being debated now by the court, and all you have to know for McDonald is that it says that states cannot ban gun possession in the home because the Second Amendment is an individual right. All right,
Now,
that was 5 minutes. That wasn't too bad.
Wasn't too bad at all. We have 4 more to go. We're looking at equality. This is the big picture idea of looking at the Equal Protection Clause in the 14th Amendment. We do have a nod to the 14th Amendment with incorporation that we can kind of pull through, and then dive into the case of Brown v. Board of Education for one of our last 4.
I'm going to do all these 4 together just for the heck of it. So we're going to talk about Brown, Citizens United, Baker v. Carr, and Shaw v. Reno. Okay, Brown, perhaps the most important case of the 20th century. You know it well. It said that separate but equal in the school context is inherently unequal. It overturns Plessy v. Ferguson, which had held the opposite, and holds that because segregation is likely to affect the hearts and minds of Black students in ways unlikely ever to be undone, it violates the Equal Protection Clause, period. And Brown was unanimous. That's Brown. It's a shining example of a case that everyone agrees was correctly decided, liberal, conservative, and everyone in between. And it's considered one of the court's finest moments. Citizens United was decided in 2010. The court struck down by a 5-4 vote parts of the bipartisan Campaign Reform Act known as McCain-Feingold because it said that political spending under the First Amendment is protected because money is speech. That's something that the court had held previously in the case called Buckley versus Vallejo, and that restricting corporations and labor unions from funding partisan communications out of their general funds violates their First Amendment rights. Baker and
Last
Carr.
two.
What? Last two. Absolutely.
Last two. We got it.
I'm just saying what the cases say. This is the easy part at the very end. Baker v. Carr. Interestingly, Chief Justice Warren, who presided over Brown, said was the most important case of his tenure. He thought Baker v. Carr was even more important than Brown v. Board of Education. What could have been more important than ending segregation? Well, fair elections, in Warren's view, because this was a time when electoral districts were drawn in ways that gave some people a lot more voting power than others. Some districts had, 4 people in them and they had 1 congressional representatives, and in other districts had 40,000 people in them and had 1 representative. And that gave the people who lived in the small districts a lot more power than those who lived in the big districts. And Baker v. Carr announces the principle of 1 person, 1 vote, and says that you have to have districts that are roughly equal in population to avoid giving some people much more power than others. And the final case is Shaw v. Reno. This is a really complicated series of cases, but the bottom line is that you can't draw voting districts on the basis of race in ways that create very funny shaped districts. I can't really describe it much more specifically than that because it wasn't exactly clear what made a district funny looking or how much race consciousness was too much, although in subsequent cases, the court said that race can't be the predominant purpose in drawing voting districts, even though Congress had said in a series of amendments to the Voting Rights Act that you got to take the interests of minority voters into account. And when there's a lot of racially polarized voting, you've got to draw some districts where minority voters have the chance to elect representatives of their choice. But the court said when you do that, you can't create really funny shaped districts. The bottom line here is the people who are drawing the districts are balancing 3 separate efforts. One is to maximize the voting power of minority voters, as Congress said they had to do. The second is to try to create districts that don't look too funny, where basically people live roughly next to each other. And the third is to protect incumbents. What do you think that the people who are drawing voting districts want to do? They want to guarantee their own seats. Now, if you took away any of these 3 goals, if you wanted to protect incumbents and maximize minority votership, but have really funny shaped districts, you could do that. Or you could have nice regularly shaped districts that maximize minority voter strength that harmed incumbents. But when you try to do all 3 things, you get crazy shaped districts like the one in Shaw v. Reno, where the court noted someone who observed that you could draw down the middle of the districts with both of your car doors open and kill people on both sides of the car because the thing was so narrow because it was drawn in such a funny way. But this was the beginning of a very hotly contested series of decisions about how much, if any, Congress can and legislators can take race into account in drawing voting districts. And that debate continues today. 140, Curry, amazing.
We did it. Very good. Well, you did it. I really just helped push you along with images. You're right. So many of these conversations we're still having today. This is why these court cases are so important for AP students to study, as well as all of our students today. So Jeff, thank you for help prepping them all to understand the past of these cases, how they impacted that time, and how we're still talking about them today. Literally, my lecture earlier today was on, is Congress have the right amount of people representing them? So really fascinating conversations going on. Thank you so much, Jeff.
Thank you, Curry. Thank you for listening, friends. And remember what I started off by saying. I know I was talking fast and maybe you're getting all keyed up, but you've got it. You know these cases. And if you want to do a final bit of prep, just read read the cases again. You don't have to, because I know you know them, but you can skim them, you can read the excerpts that you have, but just have the confidence in the text. And I know that when you go back to these cases, you'll remind yourself what they say and understand their basic principles, and you're going to do such a great job because you love the Constitution so much. You're showing up for these Friday classes and nerding out with Curry and me, and it's just such a privilege to learn with all of you. So I'm sending you all sorts of wonderful thoughts for the exam. You'll do great, and can't wait to see you when it's done.
Fantastic. Thank you, Jeff. Good job, students. Remember, you've already done all the learning, so you've already won. So thank you very much. It's very nerdy of me. It's not about the grades, it's about the learning. So have a great time. Good luck on your test. And thank you, everybody, for joining us.
Thanks, everyone. Bye.
Good luck, everyone. Talk to you later. Colin, we can work on that, right, Colin?